So today, Jessica and I will be telling you all about copyright. We're going to start with some basics, and then I'll pass the mic over to Jessica to talk about the function of the office, some details about registration, and highlighting some of our fantastic resources. And then we will leave time, of course, for some questions at the end, and then leave you all with some information about how to get in touch with the office going forward. So with that, we can get started. So what is copyright? Copyright is a type of intellectual property. The other types include patents, trademarks, and trade secrets. And Jessica will talk a little bit more about each of those later in the presentation. But let's start with the building blocks of copyright. Copyright protects original works of authorship that are fixed in a tangible medium of expression. So those three elements, we'll break down each of them today, but that's what you have to remember going forward. Original works of authorship that are fixed. And once you have those three elements, you have copyright. So if you're an author, you become a copyright owner the minute those three requirements are satisfied. So first, what are works? What are works of authorship? The law provides these categories of the subject matter that's protected by copyright. So you might recognize many of these things. Literary works, obviously at the top for our writers. This includes things like novels and poetry, and even computer programs can be protected under the literary works category. Then we have musical works. This is compositions and any lyrics. So for this category, think of things like sheet music, for example. Then we have dramatic works. This includes things like plays and operas. So this includes works that are meant to be performed. Pantomimes and choreographic works, including certain types of dances. Pictorial, graphic, and sculptural works. Motion pictures and audio-visual works. This includes things like TV shows and video games. Sound recordings, this is a recorded performance. So this is separate from the musical works. This is actually the recorded performance of the song. So technically music encompasses two different categories here, the musical work and then the recorded performance. Sound recordings, though, can also include things like audiobooks and podcasts. And then finally, architectural works. This is our most recent category. It was added to the law in 1990, and it covers habitable buildings as well as associated blueprints. Now, what's not on the slide here is material that is not protected by copyright. This includes things like ideas, methods, processes, systems of operation. Some of those things might be covered under patent law, but they are not covered under copyright. So think of an idea separate from the expression of the idea. So if you think of a romance novel, but then we say, oh, Pride and Prejudice. Pride and Prejudice is the expression of the idea there. So Pride and Prejudice could be protected by copyright, not the idea of the romance novel itself. Okay, so our second building block, originality. Originality, very important. It has two different components to it. The first is independent creation, and the second is sufficient creativity. So independent creation simply means that it has to be independently created by the author, right? It can't be copied from somewhere else. But in theory, you could have two works. They could be the same. They could be really similar. And as long as those similarities are just by chance and they're not the result of copying, there could be copyright protection in both of those works. Then we have sufficient creativity. This requirement just means that the work has to have at least a spark of creativity. It doesn't mean that the work needs to be innovative or particularly surprising. It just needs to be more than routine, typical, or mechanical. So for example, words and short phrases and slogans, those do not meet the creativity bar to be protected by copyright. So book titles, stock characters, those don't meet the level of creativity that's required for copyright protection. They might be protected under trademark law, just not copyright. And finally, our third building block here, a work needs to be fixed. So fixation just means that the work needs to be written down or recorded somehow so that you can hear it, you can read it, or it could potentially be copied. It has to be in some kind of tangible medium. So if you're writing poetry in a journal, you're putting pen to paper, you're fixing your work. If you're typing on a word processor on a computer, you fixed your work. So usually this isn't really an issue, but just to give you a counter example, things like live performances, if they're not recorded or filmed, they wouldn't be fixed, right? Because you can't perceive them or copy them later. They're not fixed in a tangible medium of expression. So most of the works are going to be fixed by their very nature. So now that we've gone through our 3 building blocks, a work of authorship, that's original, that's fixed. Remember that you have copyright protection the moment you have all 3 of those satisfied. Many people think that you need the registration certificate from the Copyright Office. You actually do not in order to have copyright ownership of your work. That right is automatic. There are a lot of benefits to registering with our office, which Jessica will go over, but it is an automatic right that you have. So as a copyright owner, what rights do you have? There are 6 rights in the law. The first is the right to make copies. The second is to make derivative works. Now, derivative works just means to adapt or transform or recast something. So a really common example is turning a novel into a film, right? Think about our Pride and Prejudice example again. The novel was made into a film. That film is considered a derivative work. You have the right to distribute your work to the public. That means you can sell it, rent it, lease it, or lend it out. The right to publicly display or publicly perform your work. Now, this only applies to certain categories of works, right? Because an architectural work, for example, can't really be performed. So it depends on the type of work that you have. And then the right to authorize others to exercise any of these rights. Our 6th right is the right to publicly perform sound recordings by digital audio transmission. That one is really specific. It really applies to when you're streaming things online, for example. But as a copyright owner, the main thing to remember here is that you have the control. You have the right to do any of these things and to authorize others to do any one or multiple of these things. And if someone, without your permission, makes use of your work in one of these ways, it's copyright infringement unless an exception or limitation applies. So what if you want to use someone else's work? The flip side of the coin here, you're a copyright user, you see something online, you'd like to make use of it, let's say it's a photograph or something else in your work. The first thing is ask permission. You can reach out to the owner of the copyright and ask for permission to use their work. That's the simplest route here. They might say, yes, you have permission. They might grant you a license and you have to pay a fee in order to use it. That's pretty straightforward. The second is public domain material. How many of you here have heard of the public domain? Public domain? Awesome. So not a place, right? It's a concept, and things fall into the public domain now on January 1st of every year. It also includes work that doesn't meet the threshold of creativity that we talked about earlier. But most famously, it's works where the duration of copyright has run out and then it falls into the public domain. If something is in the public domain, you do not need to ask anybody for permission to use it. Any one of those 6 ways we just went over, it's free for you to use. You don't have to look up a former copyright owner. It's in the public domain. Anyone can use it. And then 3, consider the exceptions, right? There are certain carve-outs for libraries and archives for very specific uses, like to preserve works and things like that. Face-to-face online teaching have certain carve-outs. And then, of course, our famous fair use exception, it's actually a defense to copyright infringement. Only a court can determine if something is fair use. So you might see online people saying, oh, this is news reporting or it's commentary, it's fair use. Them declaring that does not mean that legally it's fair use. Only a court, only an adjudicator, a judge, or a copyright claims officer can decide whether something is fair use. So that brings us to our last point. If you're not sure, we ask that you contact an attorney. They're the ones who can make that assessment for you. Fair use in particular is a very fact-specific analysis. So it's really helpful to have an attorney consult if you're not sure about using somebody else's work without permission. And then my last slide here on copyright basics is copyright duration. This segues nicely from our public domain discussion. So copyright duration is a concept that actually goes back to the Constitution. The copyright clause in the Constitution says that authors will have their rights for limited times. So what that means is that copyright eventually expires and then it falls into the public domain. Works that are created after 1978, that copyright lasts for the author's lifetime plus an additional 70 years. For this other category, works made for hire, that's works that an employee prepares for an employer, or a work that's specially commissioned. That term of duration is a little different, as you can see here, 95 years from the year it's first published, or 120 years from creation, whichever is shorter. Also included in that category are things like anonymous works, works that have no name on them, and pseudonymous works. Think of fictitious names, pen names. Those have the same duration as that works made for hire here. For works before 1978, The duration rules get a little complicated because the law has changed over time and the duration rules have changed over the years. So determining whether something is in the public domain that was created back in like the 30s, 40s, 50s, that gets a little bit more complicated with the duration rules. It's best usually to seek an attorney if you're trying to figure that out. And we have our online resources, which Jessica will talk about, to help you find those records. So with that, I will turn it over to Jessica to talk about the office.
Yeah, thanks, Laura. So we're going to switch gears just a little bit and talk about who the Copyright Office is and the services that we provide to the public. So first and foremost, we were founded in 1870 as a separate department within the Library of Congress. That does mean we're a federal agency within the legislative branch of government. And our main responsibility is to administer U.S. copyright law. So that's a pretty broad statement, but what that entails is things like maintaining and creating records related to copyright ownership. We also develop regulations in all aspects of copyright law. We advise the courts and Congress on domestic policy, as well as international delegations on international copyright law. And then last but not least, we do provide a lot of authoritative information on copyright, like Laura mentioned, to the public through webinars, through presentations like this and the like. So one of the main services we wanted to cover with you today is called copyright registration. Copyright registration is actually not mandatory, but it is something that you should consider because it does provide a lot of legal benefits, which I'll cover in the next slide. But your main thing to know about registration really is that, like Laura mentioned, it's not mandatory because the minute that you create that work, it's no longer just an idea in your mind or an idea in your imagination, and it's out in a form that other people can see or hear. That is when copyright begins. As for these 2 points at the bottom, copyright registration can only happen with the United States Copyright Office here in the US. And then 2, there's actually no need to re-register at a later date or renew your copyright. So just a couple of points to remember. So in terms of registration, it does enhance the protections that copyright already provides. And like I said, we wanted to cover some of the benefits of registration. First and foremost, registration creates a public record of your creativity. That means that that record is going to contain important information like who is the author, who's the owner, what's the title of the work, and then also if it was published, where and when it was published. Laura mentioned a little bit about this about asking permission from the copyright owner. So those records actually allow you to also find contact information for the copyright owner and be able to reach out to them and ask for that permission to use their work. And then last but not least, generally, copyright registration is voluntary, but it's actually mandatory if you are wanting to access the federal courts or the Copyright Claims Board when it comes to a copyright dispute that you might be in. An example of a copyright dispute, of course, is copyright infringement. And like Laura said, this bears repeating. Copyright infringement doesn't just mean that someone's copied your work. It means that a violation of any one of the 6 exclusive rights of copyright might have occurred. So for access to the federal courts, you must have either submitted a registration to our office and gotten that approval, or even gotten a refusal for the registration in order to file your lawsuit in federal court. So 3 simple things required for copyright protection, registration, I apologize. The first is a completed application form. The types of application forms that you might use will differ depending on the type of work that you're trying to register, like literary or musical or visual, and then the number that you're trying to register as well. The second component here is that you have to submit what's called a deposit. A deposit is just another name for the copy of your work. So if you have a novel that you want to submit for registration, it's going to be that novel. And then lastly, a fee. So the fee depends on, again, how many types of works and how many different works you want to register, and then the types as well. One thing to keep in mind with fees is that there's an inexpensive application option called the single application. It costs about $45. But we actually refer most people to the standard application. That one costs $65 and suits most people's needs when it comes to registration. All right, so now that we're done with registration, we just wanted to be sure we talk a little bit about other resources that the office provides. So the Copyright Public Record System, or CPRS, is an extremely valuable tool. It does contain information and copyright records related to registrations and recordations of ownership from 1978 to the present. And again, it does have information too about who the author of the author and owner of the work is, when and where it was published, if it was published. And so in that way, you can use it as a tool to research the status of somebody else's copyright work. That comes in handy once again if you're looking to ask permission to use the work. So within that record, you again can find that contact information. So the Copyright Public Record System is part of the Enterprise Copyright System, which is an initiative the office is continuing to hold, and it is essentially offering more streamlined alternatives and options to the services that we provide and the way you interact with the office. So with the Copyright Public Record System, we do have, for example, advanced search features and other sorts of filters and functions within this relatively new platform that you can utilize. And just so you know, CPRS became the official public catalog as of June this year. So some of the fun stuff includes Copyright Office videos. The first one we wanted to point out is Copyright Learning Engine videos. Those can be found on our website as well as YouTube. Basically, they just introduce a variety of concepts. Like Laura talked about fair use today, we have a video on fair use. You can see on the screen here we have a Copyright for Writers video as well. You can also check out things related to joint works and works made for hire and more. On the right, we have the Copyright Essentials webinar series. It's a relatively new series that we've been hosting. This year, we did a multi-part series that was focused on copyright and what creators should know in different industries. So that includes literary authors as well as visual artists, photographers, and musicians. But on the screen, we do have the August webinar that occurred, and it was related to what authors specifically, what writers should know about copyright. And so that recording can be found on our website for you to access as well. All right, so in terms of publications, we have a few fun ones we wanted to point out here. The first are circulars. Circulars are basically just narrative descriptions and explanations of the basics of copyright as well as specific areas of copyright. We do have a number of circulars that actually address literary works very specifically, so you might find those helpful. And as for the other two here, we have a business handout, small business handout, and it's what small business owners should know about copyright. Maybe you write as part of your business or as part of somebody else's business. Say you have a website and you have a mission statement that you've written or just information that you've compiled on the website. That's going to be something useful to know for you as a small business owner. And then lastly, I see a few kids out in the audience. I know we've seen families out here today. Copyright for Kids in our new handout just essentially helps parents and educators kind of talk through what Laura and I covered today on copyright, but kind of breaks it down in that simpler, easier way to understand. So it has various activity sheets that kids can complete and fill out. All right, so the last slide here is our Public Information Office. Just know that, Laura said we're going to answer questions today, but if you have any additional questions after today's presentation, or let's say you're sitting down to submit your registration and you're just not sure what to do or where to go, the Public Information Office is a really great place to start. So we have staff in this office who are prepared to even walk you through an application online. What that means is that you can schedule an appointment with the office, and that staff member will take about 30 minutes of time to explain the various screens of the online registration process. They won't give you legal advice, but they'll certainly help you kind of come to the answer on your own, as well as read additional resources to help you make your decisions. But otherwise, just know that our website is copyright.gov. You can always reach out to us and find our resources there. We also have this email address and the 2 phone numbers that are wonderful ways to contact us as well. All right, and our last slide is just basically a reminder that copyright is everywhere. As you're walking around today, maybe as you're sitting in a coffee shop or sitting at your own desk, just remember that copyright is probably all around you, as are other forms of intellectual property or IP. The graphic here shows, for example, a cat, which is a sculptural work, some of the books, some of the artwork in the frame, as well as the photographs on the computer screen. There's music coming out of the speakers that's protectable by copyright. And Laura mentioned the other types of intellectual property include patents, trademarks, and trade secrets. So just a brief overview there. Trademarks do protect brands, essentially, the names and the slogans that are used to identify or help consumers identify the source of what they're buying or using. And then patents protect inventions or discoveries and the like. As for trade secrets, you'll see those are kind of pointed out in our confidential folders. So trade secrets do protect commercially valuable information that is not known to the public. And its secrecy essentially is part of why it's so valuable. So as for the image, I absolutely love this one. I hope you'll check it out. It's actually in our copyright registration toolkit. This is something that we released back in April, and we're very excited to have it on a landing page where you can see this graphic. You can explore the different types of IP, including copyright, and you can find toolkits on the other areas of IP as well. But we have this QR code here, and then our table is actually just outside this pavilion, so you can always go there and scan or pick up various business cards to learn more as you continue your copyright journey. But with that, we're happy to take questions.
Hi, yeah. You said that you cannot pursue like a court case unless you have like copyright registration. If you feel like you've had copyright infringement, can you then file for registration and then take it to court? Or
Yes.
does it need to be the other way around?
No, you can submit for registration at any time, but there are benefits to filing before the infringement occurs, including the fact that your attorney's fees could be covered, the fact that statutory damages will then also be available to you, but you can register at any point.
Thank you for that introduction. Can you just tell me what would happen to somebody who creates a work under a nom de plume and registers with the Copyright Office? Is their privacy protected in some way?
Yeah, that's a great question. So I think what you're talking about here is pseudonymous works. So if it's a pseudonymous work, that has obviously, as I mentioned, implications for the duration of copyright. So if only the pseudonym is on the record, that's absolutely fine. When you're going through the application, it does ask for your name in certain places, and we do have some people that actually end up putting both the pseudonym and their real name on the application. And in those cases, in order to remove or replace that real name, you do need to have a legal name change certificate to submit to us. So when you're going through the application, just be aware of information you're putting in, and if you have any questions, you should definitely call our office or the registration specialist and just make sure that you're putting in exactly what's required and not anymore. But we do have more information on our resources, exactly to your point about, what information is required, can I just put the pseudonym everywhere, etc.
Hi, how you doing? I just have two small questions. The first is I filled out for a copyright, sent in my content, paid my fee. It's been 7 weeks. I'm just wondering when it comes through.
And you
And-
submit it online?
Yes.
Okay. Yeah, processing times vary just depending on whether or not the office needs to reach out to you and has questions about the application.
I got the little yellow box that said everything's complete, everything's in. I'm just waiting.
Sure. Yeah. I mean, it does take about, I think we're running 10 to 16 weeks dependent on
Oh,
how,
okay.
yeah, depending
oh,
on how long.
No problem then.
Sure.
And the second question is, if I find a formatting issue or a typo in my manuscript, how much can I change that before it becomes a new product? And I have to apply for another copyright.
Yeah, so that's a great question. So just small edits, right? Like typographical, grammatical mistakes, that's not going to rise to that sufficient creativity level we were talking about. So that's not going to result in like a new derivative work that you would get like extra registration in. Just those small changes are not really enough to turn it into a new version. But if you add like new chapters, for example, then you could register those new chapters. Yeah.
Thanks. I'm very interested in works that are now in the public domain. And as you mentioned, this happens every year on January 1st. In my limited experience, it seems like these are very case-specific inquiries. But do you know of any resources or techniques that can find, hundreds or thousands that are entering at a time instead of that case-specific inquiry?
Sure. In terms of like what's entering the public domain, it's usually a specific year in time. So for example, I think works entering the public domain this coming January will have been published during the year 1930. So it usually follows that sort of pattern, every year from that decade on essentially will enter the public domain. There are sorts of limitations, including whether or not the copyright was later renewed, which could have happened under the older laws. But with public domain resources, the office does have a blog that we publish every January or every year as well, kind of covering what those works are. And then we do often link to the registration records for them, as well as trying to kind of help you all understand how to research those within the copyright public records system. Hopefully that answers your question.
How exactly does copyright work for joint works?
Yeah, that's a great question. So joint works are created when both authors intend to merge their contributions. So at the time the work is created, they're both intending that it becomes one work. And then both of those authors and owners can exercise any of those rights. They don't have to ask permission from each other. But if there's any profits made, they have to account to each other. The profits have to be split 50-50. So there can be dual ownership in specific cases where they're intending that the contributions merge together.
Thank you. What's the deal with cover bands if it's a private performance at a small club? And then what? Secondly, follow on. What if it's there's a YouTube recording of that?
So with covers especially, that is a form of a derivative work because it's taking essentially somebody else's underlying sound recording usually and then kind of adapting that into their own cover. So with that, you do need to ask permission generally from the copyright owner in order to do that. I don't know if that answers your question in terms of the space, but hopefully that gives you some of the foundational knowledge. And then as for YouTube, same sort of concept where, again, if you don't have the permission from the copyright owner to even create that, then putting that online could also be implicating the exclusive rights that we talked about, like publicly displaying the work online, etc.
Hi, thank you for the presentation. So if I have a rough draft of a novel, I submit it, it gets copyrighted. But if I had to add like 4 more chapters, do I have to submit a brand new copyright, or is there an amendment system in place?
That's a great question. So this kind of goes back to the question I was answering earlier about small edits versus larger edits. So with a larger edit like that, where you're adding whole new chapters, when you register those manuscripts, I mean, that is definitely up to you. But to the extent you're adding new material, it's considered a derivative work, and your new registration could cover just the new material, essentially.
Yes, I understand that if you have like a patent, then once you have disclosed the information in the patent, other people can see that. So I wondered if copyright is the same way. If you copyright something and somebody can look up and see that you filed for a copyright and they can look for your name, do they have access to the material that you submitted for the copyright? In other words, if there's 2 people writing on the same subject, can they go get the material from the Copyright Office, that you have submitted?
So generally, no. The deposit, which we talked about, was like the copy of the work that's posted or given to the registration office, is not going to be posted online, is not going to be accessible by others. Now, that's a general rule, and so there is an exception, especially if in litigation that work comes up, then you'd have to request, for example, through an attorney or through an authorized agent to get a copy of the work in order to kind of help with that lawsuit.
I was just wondering with, AI and the large language learning models, if there has been any determination made if that is like a derivative work, or is sort of like the jury's still out on those. I know there's lots of active lawsuits pending right now, so just wondering if you could speak to that.
Yeah, sure. So, obviously a lot of litigation out there with some big news that's coming down, every day, every week about this. The office, is really looking into this issue very closely. We have our AI initiative, and you can, when you access that webpage, you'll actually see we've published 2 parts of a report already, and then another third pre-publication version covering digital replicas, copyrightability of outputs, and then, as you mentioned, what the potential liability is of the inputs into those systems. So they're pretty dense reports, but it's really a culmination of a lot of hard work by the office. We got over 10,000 comments to our AI study, and the office really distilled all of that and analyzed it and put out these reports about the office's position on AI. But obviously, we're also all watching what the courts will be doing as well.
Hi, thank you so much for your presentation. I have a question about sort of along the lines of joint submissions, things that are both a creation and a performance. So like an audiobook narrator and the writer, or the composer and the musicians. How much, engagement does your office have in those like agreements between people about the performance of the thing versus the origination of the thing? and like the rights of the performer versus the rights of the creator when it comes to like selling or profiting from the work?
Sure. So the office, the Copyright Office at least, does not have any part to do with the contractual negotiations or even the creating or writing of that contract as well. So that'll be up to the parties. But when it comes to registration, especially of musical works and the sound recording, like Laura talked about, there is the sound recording itself, which is the performance perhaps of that song, and then the underlying musical composition. So those are actually two separate works. They are each subject to copyright protection, and in certain cases they can be registered together on one application if the copyright owner is the owner of both of the works. Hopefully that clarifies and gives you, once again, some foundational information. But we do have some business cards at our table. Again, it's just right out here. One of them is copyright specifically for musicians. We also have cards for copyright for writers. And then we got the AI questions, so we do have a copyright for AI card as well. But with that, I'll give it to Laura for our last slide.
Thank you so much, everyone, for attending the presentation today and for all of your great questions. How to stay in touch with us. We are on X, LinkedIn. We have our YouTube videos, our recorded webinars, and then our Newsnet. You can find updates if we're publishing a new study or rulemakings or we have another event coming up. Subscribe there and you'll get all the updates, and then visit us online as well or call our office. Thank you so much.
Thank you.